Hello and welcome back to Success Seeker. Friends, today in this video, I have done the revision of important bodies of polity, which will be very helpful for your upcoming examinations. It is actually a revision of the important bodies, and I have made the note in a comparison manner. I have completed in 5 pages to almost 23 chapters. So I hope it will help you in your examinations. So without wasting any more time, let's start. First is the Election Commission. Election Commission, as you all know that it is covered in Article 324, and it does the election of Parliament, State Legislature, President and Vice President. It has the body comprises of Chief Election Commission and Regional Commission, and all three are appointed by the President of our India, and the tenure and condition of service is determined by the President of India. Election Commission was established in 1950. 16th October 1989, two election commissioner was appointed along with Chief Election Commissioner. From then onwards, the body comprises of, or the member comprises of three, that is 2 election commissioner and 1 chief election commissioner, and both they enjoy a equal power, salary and perquisites. The salary and other facilities are almost similar to judge of the Supreme Court. The judge of Supreme Court, what he gets, the same salary or the facilities the election commissioner also gets. The term is 6 years and 65 years. This is important. From here, important is the term and who appoints and the article, that is 324. So you must be very thorough with these 3 points. Next is Chief Election Commissioner. The security of tenure is they have got the security of tenure, that is the term is secured, and they can be removed only by misbehavior or incapacity. These are the 2 reasons through which Chief Election Commissioner can be removed, and it must be passed by both the houses of Parliament by a special majority. A special majority, I hope you all know, that is 3/4 of the houses permission is required. And the next is not so here it is also given that the President's pleasure is not there for Chief Election Commission, means President cannot remove any time the Chief Election Commissioner or the other commissioners. Recommendation of Chief Election Commissioner must be for removal of election commissioner and regional commissioner. So if you have to remove the election commissioner, 2 election commissioner and the other regional commissioners, you have to get a recommendation from the Chief Election Commission. So he acts as a head out of these 3 members. Next is the qualification. The qualification is not prescribed in the Constitution of our India, and the term of the member of EC, that is Election Commissioner, is also not mentioned in the Constitution of India. Election Commissioner can be reappointed, very important. So Election Commissioner can be reappointed, and the term, for how much term he can be selected, it is not given in the Constitution of India. And the Chief Electoral Officer, that is CEO, in the state, it is in the state, it is appointed by the state government in consultation with the it is appointed by CEC and in consultation with the state government. So this is all about the election commissioner or election commission. So mainly you have to know the article 324, and the term is 6 years, 65 years, and appointed by the President of India and he can be reappointed. This 3-4 points you have to know. Next is UPSC. UPSC, it is Union Public Service Commission. It is the watchdog of merit system. That is through merit only you can get in the UPSC. That is All India Services. Next is Article 3. It is under Article 315 to 323. That is under Part 14. Part 14, 315 to 323. It has a total members are chairman plus 9 or 10 members. That is 9 to 11 total members in UPSC. President appoints all the members and chairman, and it is on the discretion of president. No qualification prescribed except half member should be from Government of India or state government posted for 10 years. That is, actually no qualification is mentioned to be a chairman or other members, but the person whom to appoint, he must be a Government of India or state government members or employee of Government of India and state government. Term is 6 years. So Election Commission was also 6 years, and this is also 6 years. These terms are very important, and it is very confusing. So you must have a watch of these special terms. So here the term is 6 years or 65 years, and he can resign to president. So chairman can resign to president, and can be removed also by the President of India. President can appoint acting chairman. So acting chairman can also be appointed by the President of India due to vacancy or absent. Means any member or chairman, if it is vacant or absent, president can only appoint acting chairman. No other person can. Removal by president on insolvent, paid employment, infirmity of mind or body. So for Election Commission, it was misbehavior, incapacity, 2 points. Here the removal procedure by president on the issue of, that is, insolvent. He must be insolvent. He must be unpaid employment in other sectors. He must be employed, and infirmity of mind or body. That is, the mind and body is not fit for the post. On these 3 points only, president can remove the members of UPSC and chairman of UPSC. For misbehavior cause, president has to resign to refer to SC for inquiry. That is Supreme Court for an inquiry, and Supreme Court if advises, then it is a binding on president. So for misbehavior means if a misbehavior is done by the chairman or other members, president can remove him only if a inquiry has been done by the Supreme Court of our country, and if the Supreme Court advises the president to remove him, then it is a binding on president. Very, very important. So misbehavior condition is president has binding if Supreme Court advises him, and misbehavior must be profit made from agreement with Government of India. So misbehavior here, it is many conditions here arises. So misbehavior can be of any kind. A person cannot be removed on any ground for misbehavior. Misbehavior must be a particular fixed ground. That is, inquiry must be done by Supreme Court, and if he does a profit from agreement with Government of India, means on other related matters, if a profit is generated. So these two are the reasons of misbehavior. Next is salary. Salaries are given from the Consolidated Fund of India, and you know that Consolidated Fund here no vote is done. So no vote is given by the member of parliament. So salary is fixed. Chairman, no reappointment and no further appointment by Government of India or the state employment, and member eligible for chairman only, but no reappointment in the same post twice. So one important differences here it is, election commissioner can be reappointed, but chairman of UPSC cannot be reappointed, but the other members can be appointed as a chairman, but same post he cannot hold twice. So this is the difference between the UPSC and election commission. Next is provision, direction and provision. So UPSC's provision, what is the functions actually? It conducts examinations and the disciplinary action. Actually it is advisory. They gives the direction or advisory to the cabinet or the government, then the government take the step against the employee, that is the IAS officers, IPS officers. Jurisdiction can be increased by parliament. So if jurisdiction it wants to increase, then the parliament can increase it by an amendment. So other important things are also there. 14 days time for amending any rules. 14 days times must be given. It is a central recruiting authority. So you know that UPSC conducts every year civil service examinations and many other examinations, and it is advisory and not binding on government. So this I have told you before only. And individual minister cannot reject advice of UPSC. So individual minister cannot reject advice of UPSC. So it has to decide by the cabinet. Means total many ministers has to decide on the matter. Annual report to president. So UPSC must give an annual report to the president of our country. So UPSC is from article 315 to 323 and election commission is article 324. Here 9 to 10 members, here is 3 members. 6 years 65 years, here also is 6 years 65 years. Next was regarding misbehavior. You have seen that Supreme Court's inquiry is needed, and if an agreement is done by that person. So here reappointment is not given in UPSC, but in election commission reappointment is given. So these are the differences between election commission and UPSC. So we have gone through these two parts. Next is PSC, that is Public Service Commission. This is for the states. It is also in article 315 to 323 part 16. Chairman and other members are appointed by the governor of the states, and number of members is on the governor's decision. So here for the state, this is difference. Actually UPSC is appointed, chairmen are appointed by president. Here it is appointed by the governor of the state, of that state for which PSC is given. Next is qualification. It is same as of UPSC, that is no qualification prescribed, and half member should be from the government of India or state government post, that is half member should be public servant. Next is 6 years 62 years, that is here it is the difference in PSC. 62 years is maximum, you can maximum allowed for the chairman or other members. 62 years. UPSC it was 65 years, but the term is 6 years. So either 62 or 6, whichever is earlier, you have to resign. This is the resign, or you have to removed. This is the differences between PSC and UPSC. And same it is here it was resigned to president. Now for PSC it is resigned to governor. President can appoint acting chairman. Here also same, governor can appoint. Removed by the president, very very important. Removed by president only and not by governor. So PSC's chairman and other members are appointed by the governor, but removed by the president only. Here in UPSC, appointed by president only and removed by president only, but in PSC, appointed by governor and removed by president of India. Next are same, that is removal by president on insolvent, paid employment, infirmity of mind, same. Misbehavior also same. And chairman eligible for chairman of UPSC, other SPSC, but not other employment and members. So chairman, he can be, here he is eligible for the chairman of UPSC, so he can be promoted to UPSC, means appointed to UPSC. Chairman and members, no second term. So chairman and members, no second term. So no reappointment is possible here also. But he can be, he can apply for, not he can be appointed as UPSC chairman. He is eligible actually. This is the difference. Provision is directory and not binding. This is same as UPSC. Here the direction and binding is given to the state government. Here it is given to government of India. So you have to check the differences. Jurisdiction can be increased by an amendment of the state. Report to governor annually and governor before both houses. So he has to report to governor. Governor can make amendments, but 14 days before has to be placed before the state legislature. So amendment can be done, but 14 days time must be given before state legislature to actually to see what the amendment is of. It is the watchdog of merit system, same. DOPT handles training, Department of Personnel Training handles the training part of the employees who are selected by the PSC examinations, conducted examinations. Next is also JPSC, that is Joint Public Service Commission. It is actually for 2 or more states. It is act by parliament for 2 or more states requested by the state legislature, means which state they request for to form a joint PSC, then joint PSC is formed. Here you have to note that GPSC is a statutory body, not constitutional body. So it was an act which was set for JPSC. So JPSC, that is Joint Public Service Commission, is a statutory body. This is very important. Many a times it is asked in examination. So Joint Public Service Commission is a statutory body, and president appoints chairman and members. Term is same, 62 years. President determines everything. So here president determines everything in the case of JPSC. The only thing you have to note here, it is JPSC is a statutory body. It is not a constitutional body. So we are done with EC, that is Election Commission, UPSC, BSc and JPSC. Next is very important part, that is Finance Commission. Finance Commission is given under Article 280. It is a quasi-judicial body. So judicial activities can be also done, but in a limited manner. So it is a quasi-judicial body, and it is in Article 282 of our Constitution of India. Very very important, 280. President every 5 years or earlier, means every 5 years Finance Commission is appointed, and Finance Commission is appointed for it is actually appointed to seek the division of revenue share between state and union. So to settle the share, Finance Commission is appointed every 5 years. Chairman plus 4, so it comprises of chairman plus other 4 members. All are appointed by President of India. Very important. So president appoints chairman plus 4 members, and it is eligible for reappointment. So Finance Commission chairman is also eligible for reappointment. So only we have seen that UPSC's chairman is not eligible for reappointment, and PSC also. Here Finance Commission is eligible for reappointment. Parliament determines qualification. So Parliament determines the qualification what they require for Finance Commission chairman. Chairman is in public affair experience, and the chairman must have public affairs experience, means he must have the experience to deal with public affairs. Members must have experience in that is judge qualification or finance and accounts, administration or economics. Any of these experiences must suffice to become a member of the Finance Commission. So Finance Commission chairman must have public affairs experience, and other members must have this economics, administration, finance and accounts, and judge or qualification. These are the requirements or requirements for to eligible for the member of Finance Commission. Next is Finance Commission recommends to President on the distribution of taxes between between center and state. This I have already told you that center and state what tax they will divide, or this share is this recommended by the President, but it is not binding. It is recommended to President. Grant in aid to states by the center from Consolidated Fund of India. This also is decided by the Finance Commission. Supplement resource to panchayats and municipalities. What must be the supplement resource to panchayats and municipalities? This is also decided by recommended by Finance Commission. Next is report to President and action taken recommendation. This I have told you. And all the means recommendation is advisory and not binding. I have already told you this. So this is the balancing wheel of the fiscal federalism in India. Very, very important. So question may arise, question may come that which body is the balancing wheel of fiscal federation in India? It is the Finance Commission. Next is role undermined due to Planning Commission. So here Finance Commission roles is undermined due to Planning Commission. First Finance Commission chairman was K.C. Neogi. Very, very important. So first chairman was K.C. Neogi. In 1951 first Finance Commission was held. Means appointed for the term 1952 to 57, and the 14th Finance Commission was chairman was Y.V. Reddy, 2013 for 15 to 20, and 15th means now at present Finance Commission is chairman is N.K. Singh. Very, very important. N.K. Singh is the current Finance Commissioner or Finance Commissioner of our country for the term of 2021 22 to 25 26, and the other members are, some members are here given: Ajay Narayan Jha, Professor Anup Singh, Dr. Ashok Lahiri, Dr. Ramesh Chand, and Secretary is Ravind Mehta. So this is all about Finance Commission. Hope you have understood the part. Next is CAG, that is Comptroller and Auditor General. Very, very important. It comes under Article 148. It is defined under Article 148 of the Constitution. So Finance Commission was 280, and Election Commissioner was 324, and PSC was 315 or UPSC was 323. That is part 16. 14. Next is CAG 148, Head of the Indian Audit and Account Department. So he is the head of Indian Audit and Account Department. He acts as a guardian of public purse and controls entire financial system at the center and state. Very, very important. So he is the guardian of public purse. He actually maintains he is the guardian of our country's total financial condition. Next is B.R. Ambedkar said it is the most important officer, that is CAG. It is appointed by the President of our country. So CAG is also appointed by the President of our country. Term is 6 years, 65 years. So we have seen everything is 6 years, 65 years, but PSC was 62 years. It resigns to If you want to resign, he has to resign to president of our country. Next is removal by president as the same as judge of Supreme Court. Means Supreme Court judge, what is the criteria for removal? The same thing is here applicable for the removal of CAG. That is, special majority is required on the for the removal of CAG, and it is on the means criteria for misbehavior and incapacity. If these two criteria is fulfilled, then only not two means misbehavior or incapacity. If either of these two matches the criteria, then only CAG can be removed. So misbehavior, we have seen that if Supreme Court inquiry is done and give a recommendation to the president, and binding president is bound on the advice of Supreme Court, and not eligible for further office. So no reappointment. Here also no reappointment. Finance CAG is also cannot be reappointed twice. Salary is equal to judge of Supreme Court, and it is the salary is given from the Consolidated Fund of India. Next is Article 149 defines the duties and power of CAG. Very, very important. Article 149, duties and power of CAG. And CAG audits CFI, that is Consolidated Fund of India, Contingency Fund of India, public accounts, states CFIs, and state Consolidated Fund and Contingency Fund, and different departments also is audited by the CAG. So CAG acts as the main public purse of our country. On request by president and governor also, audit can be done on the local bodies. So local bodies can be also done audit by the CAG on the request of president or governor. Advise president on accounts. He can advise president on accounts if president wants. That is given in Article 150. Report is given to president. That is Article 151. Reports given to governor and the president. Article 151. He certifies the net proceeds of taxes. That is 279. That is, what are the proceeds, net proceeds? He has to certify the taxes. He acts as a guide and philosopher to PAC, that is Public Accounts Committee. He accounts as a guide and philosopher to PAC, that is Public Accounts Committee. More freedom on audit of expense than receipts. And propriety audit is discretionary. That is, propriety, if audit is done by him, that is his discretionary power. Paul H. Appleby, he criticized cats. Means this also you have to know. Means this was one of the not historian. Means he also wrote different constitution. He criticized CAG. That is Paul H. Appleby. So this was about CAG, the differences. So we have seen Election Commissioner, UPSC, PSC, JPSC, Finance Commission, and CAG. We have finished with this. Next is National Commission for Scheduled Caste. It is a constitutional body. It is given in Article 338. Article 338 defines National Commission for Scheduled Caste, and it appoints SC and ST Commissioner. In 1978, it was multi-member body plus the chairman, and in 1987, National Commission for Scheduled Caste and Scheduled Tribe was formulated. So before it was a committee. Actually, committee was there for Scheduled Caste. So in 1987, National Commission for Scheduled Caste got settled or appointed, under Article 338, and 338A is National Commission for Scheduled Tribes. So this comparison you have to know that for scheduled caste it is 338 and scheduled tribe it is 338A. 65 fifth Constitutional Amendment 1990, a multi-member was appointed for scheduled caste SC and ST. And 89th Constitutional Amendment 2003, it bifurcated two bodies, that is 338A, that is NC-SC, and 338A SC NC-ST. So before that, SC-STs there was one commission only, but from 89 Constitutional Amendment, that is 2003, very important, 89 Constitutional Amendment Act 2003, it bifurcated the bodies, that is one for SC and one for ST, Article 338 and 338A. In 2004, NC-SC established chairman. It was established in 2004. Very, very important. So 2004, NC-SC was established. In NC-ST and NC-SC both, it was established, and it comprises chairman plus vice chairman plus 3 members. Chairman plus vice chairman plus 3 members. 3 members. And all are appointed by the President of our country. And the service and tenure is determined also by the President. And it prepares a report, and the report is given to President annually when necessary. Annually or when necessary, means annually it has to give to the report to President what is the present condition for SCs in our country, and when President require or necessary, then also it has to give the report. President to Parliament and also to Governor for State Legislature. So President it gives to Parliament, and the State Governor also it is given by the President. So they give the report to President, and President gives the report to Parliament or the Governor. Next is power of civil court. So NC-SCs and STs, they have a power of civil court. They act as a civil court when required. Also for OBC and Anglo-Indian community. So NC-SC, OBC and Anglo-Indian community, it also covers this caste also. So this was all about NC-SC, and for NC-ST the same thing, 338A, only the difference is the Article 338A. 65th Constitution, same thing. 1999, a new Ministry of Tribal Affairs was formulated. This also you have to know. 1999. 89 Constitutional Amendment 2003, it bifurcated, same thing. 2004, it got settled, chairman plus vice chairman plus 3 members, that is total 3 plus 1 plus 3, 4, 5 members. It is appointed by President, service and tenure by President. 2005, President specified function, minor forest right ownership, mineral water resource, full implementation of the PESA Act 1996, and reduce or elimination of shifting cultivation. So this terms was also given by means this functions was also added in 2005 by the President of our country. Annual report to President, and whenever necessary, same thing. President give the report to Parliament, and Parliament and also to Governor of the state, and it acts as a civil court. So in 2022, the present chairman is Vijay Sampla for NC-SC, National Commission for Scheduled Caste, and for NC-ST, Harsha Chauhan. Vice chairman is Arun Haldar, member is Subhas Rampath, Ramnath Pardhi, and Anju Barai. So this is all about NC-SC and NC-ST. Next is special officer for linguistic minorities. So special officer was on the recommendation for State Reorganization Committee 1953-55. It recommended to formulate this. 7th Constitution Amendment 1956, new article was formulated, that is article number 3 350b, 350b, very important. Special officer for linguistic minority article is 350b in part 10, 5, 15, 6, 17, part 17. 350b, part 17. President appoint special officer, that is and special officer report to president. So article 350b, it defines the special officer. In constitution, no qualification tenure is given. Next is 1957, so created or commissioner for LM, linguistic minority, 1957. Next is nodal officer, headquarter is Allahabad, 3 arrows, that is Belgium, Chennai, Kolkata. It was given, it was made under Ministry of Minority Affairs, and Renuka Kumar is the present linguistic minority officer. So this is all about linguistic minority officer. From here you have to only remember article 350b and 7th Constitutional Amendment 1956. Next is Attorney General, very important. Attorney General is article 76, and he is the highest law officer of Government of India. President appoints Attorney General of India. What is the qualification? Very, very important. He must be a citizen of India. He must be judge of High Court for 5 years, or advocate of High Court for 10 years, or he eminent jurist in President's opinion. So qualification here it is given: citizen of India, judge of High Court, advocate of if judge 5 years, advocate 10 years, and eminent jurist in the perception or opinion of President. Then only he can become the Attorney General of India. It is given in article 76, and he is the highest law officer of Government of India. Next is the term, not fixed in Constitution. So term here it is not fixed. Pleasure of President, he acts on the pleasure of President. Tenure and removal, resign to President, conventionally resign when government resigns and replaced. Means here it is a one convention is there, that is when the government resigns, then automatically he has to also resign from the post. Next is remuneration, not fixed in Constitution. President determines. Remuneration means salary is not fixed. President determines Attorney General's salary. He is the chief law officer of Government of India. Very, very important point is right to audience in any court, that is right to speak and take part in both houses of parliament or joint committee is where his name appears, but he cannot he does not have the right to vote. Means he has the right to audience in the parliament. Also he can speak, but he cannot vote. Privileges and immunities of MP, what an MP gets, the same Attorney General also get. That is given in Article 105. Next is permission required for him for defending criminal cases or to be a director in a company. Means if he wants to become a defending criminal judge for other cases, he has to get a permission from the president, and he must be or any director of a company. Then permission is required for him. Not be debarred from private practice, means he can do private practice also, but you have to remember that it is not in the case of CAC. CAC reappointment is not there, and he cannot do a further practice. Not a full-time counsel. K.K. Venugopal was the Attorney General of India. So here Attorney General is also very important, and you have seen the Attorney General of India. Next comparison is with Advocate General of the state. Attorney General, if you have to compare, it is Advocate General of the state. It is given in Article 165. So Attorney General is 76 and Advocate General is 165. It is the highest. He is the highest law officer of the state, appointed by governor, same as the Attorney General, but here some difference is there, that there it was president, here it will be governor. He must be a citizen of India. For qualification, here judicial office for 10 years, advocate for High Court for 10 years. So Here one extra thing is added here, that he can be for qualification, judicial office holder can also become an Advocate General of India if he have served for more than 10 years, and if he was an advocate of High Court for 10 years also, he can become the Advocate General of India. But for Attorney General, he must be a judge for High Court, an advocate for 10 years. Next is the term, not fixed in the constitution. Here also same, pleasure of governor, pleasure of president, there it was pleasure of president, resigned to governor, here it was resigned to president. Conventionally resigned to means when the government resign, he has to also resign, it is a convention. Governor determines the remuneration, same thing, everything is same. Here it will be governor. He can speak or audience in the state legislature, not in the parliament. Here it was parliament. Same thing, he cannot, does not have the right to vote. Article 194, privileges and immunities of means member of state legislature, MLAs. S.N. Mukherjee in West Bengal, he was the Attorney General of the. Kindly subscribe and like my video, and I will be uploading the non-constitution bodies in the next video. Thank you.